Welcome, everyone. Thank you for joining us for our very first webinar. We're thrilled to have you here. Many of you are already familiar with our trusted advisors, Harry, David, and Kevin, but today we're especially excited to introduce our distinguished guest speaker, Lyle Perry. Lyle, thank you so much for being here with us today. Lyle's expertise spans continents. He was admitted as an attorney in South Africa in 2010 and later called to the BC Bar in 2018. As a lawyer and partner at MHWP Law, located in the heart of downtown Maple Ridge, Lyle has built a strong practice focusing on business law, real estate, and wills and estates. With years of experience guiding families through the estate planning process, Lyle brings invaluable insight into drafting wills, powers of attorney, and representation agreements. His deep understanding of business and real estate law ensures that your estate plan integrates seamlessly with your financial interests and property holdings, setting you up for long-term success. So before we get started, I just have a few quick housekeeping notes for everyone. We expect that today's webinar will be roughly 1 hour long. We will try and carve out some time towards the end of the session to answer any questions we receive. So if you do have any questions, you can submit them in the Q&A chat, which should be located at the bottom of your screen. And a recording of this webinar, along with responses to any unanswered questions, will be emailed to you within about a week. So before diving into our main topic of estate planning, Harry, David, and Kevin would like to take a few minutes to provide you with a brief market update.
Thanks, Les. I thought I'd start us off by just looking at what's happened at the beginning of this year. Trump got elected in November 2024, and everyone was super excited as far as the market goes. And people go, well, why would they be excited? Well, he talked about massive deregulations, huge corporate tax cuts. So, of course, these things are really positive for the market. So the market really got off to a great start in January. Unfortunately, then Trump got onto his tariff soapbox. And Kev, why don't you tell us what happened starting in February?
Yeah, since February, the financial markets have been particularly volatile as Trump rolled out his trade war. And it's caused a lot of just uncertainty, which markets don't like. The tariffs have caused a lot of concern within the global economy. Policy uncertainty makes it very difficult for companies and businesses to create plans and unroll those plans. Some companies have suspended guidance to their investors. Tariffs, despite what Donald Trump will sometimes try to say, are ultimately a tax, and more tax equals less money for you and I to spend on stuff in the consumer market. Trump has backed off very recently in terms of his talk around tariffs, and he is claiming now that negotiations are happening with a number of different countries. And markets are beginning to be more optimistic that free trade, for the most part, will regain some of its norm on a go-forward basis.
Why don't we, let's take a poll question here before we get over to David and see what everyone's answers are to those this poll question.
So everybody should have on their screen just a yes or no question there. Do you expect the U.S. stock market to finish the year higher or lower than it is today? Just curious to see what everyone thinks.
So it looks like 76% voted yes and 24% voted no.
Awesome. That's great to see. I think that's probably more or less what we expected. There's certainly some reason for pessimism, and understandably so, but I think most of us here too would agree that I think there's a pathway forward for the market to finish higher by the year end compared to where it's at today. Just given the fact that Trump's backed off significantly in recent weeks, and hopefully in the next coming weeks and months, we'll start to see some momentum build as far as him actually unveiling some hard and fast agreements with certainly Canada first and foremost would go a long way for us here in North America, and then obviously the big domino is with China. So we'll sort of have to see, I guess, where things shake out. But I would think that Harry, Kevin, and I would agree that we think the market should finish higher by year end, so long as Trump behaves himself. So I think now that we've done the poll question, I think it's just useful to sort of look back just quickly here on how people can feel when it comes to investing and going through different market cycles. You know, obviously the last 5 years, almost 6 years now, I guess, going back to the COVID pandemic, there's been a lot of ups and downs in the markets as we've gone through, you know, a couple of bear markets. Obviously in COVID, in 2022, there was a bear market as well. And we just about had a bear market as recently as April, early April, when Trump announced all the retaliatory tariffs. The U.S. market dropped 19.8%. So 20% would classify as a bear market from a peak to trough drawdown. So we've almost had 3 corrections since 2020. And so there's certainly been, we've run the gamut of emotions as far as investors go. You know, in late 2022, coming out of a peak inflation period over the summer of 2022, where inflation was upwards of 9%. Markets were not optimistic. You know, it was everyone thought the Fed had blown it, that the interest rates would be high forever and inflation was here to stay. But eventually inflation did moderate and interest rates came down. And so we had a little bit of optimism heading into 2023. We had 2 great years in 2023 and 2024. And by the time we got to January of 2025 with the Trump bump in the first few months, I think markets were feeling maybe a little bit euphoric at that point in time. And then, you know, fast forward to a few weeks, or I guess a month and a half ago now, you know, early April, on April 2nd, Trump made his infamous Liberation Day speech and announced all those retaliatory tariffs on that big, beautiful poster board that he had. And the markets, you know, tanked for 3 trading days, dropped about 12% across 3 trading days. And then suddenly, whether it was the financial markets or people around him, whether it was business leaders in the United States or some of his Republican colleagues, just saying, hey, like this policy doesn't make sense. He's obviously backpedaled significantly on, I think it was April 9th there. And then the market rallied 10% in one day. So, you know, it just goes to show that it's normal for our investors, even us advisors. You know, we feel these emotions too, to some degree. It's normal. But we've certainly run the gamut in the past couple of years as far as the emotions goes. And I think it's, if we fast forward to this chart, you can just sort of see, you know, this is where the S&P 500 is today. So it's recovered quite a bit from that April 2nd Liberation Day announcement. That's when this was. And then, you know, the markets cratered, and then they've come back quite a bit. So the S&P 500 is almost back to where it started the year. It's still a little bit off of its peak, but even just in the last couple months, we've seen, you know, investors experience a lot of emotions. Now, fortunately, all of our clients were quite well behaved in April. Nobody bailed on their investments, but that's what we see or have seen in the past, is that, you know, how folks can, you know, ruin a retirement or upset or completely upset their financial plan is to react to these market cycles, especially when fear and panic are everywhere, and you know, the news media outlets are telling you this time's different. It's going to be, you know, an absolute crash, and you get out at the wrong time, right? So nobody did that this go around, and hopefully we're through the thick of it, and Trump again will behave himself going forward as far as his tariff policy and his trade policy. I'm sure it'll still be a bumpy, much longer we've got, a little more than 3.5 years still to deal with this. But you know, his policy and his I guess the way he delivers news and the way he speaks in front of the podium doesn't provide a lot of clarity on where things may be headed. But at least for now, he's backed off quite a bit, and appears that you know, trade policy will be more normalized going forward. So we'll start to have to see that actually come to fruition for the markets to move forward for the rest of the year. But hopefully that provides a quick update. I think most people are pretty well aware of where things stand today. It's obviously been a very popular thing for people to keep track of, especially us as Canadians, with all the 51st state rhetoric. and the impact that it will have on our economy should those tariffs actually have gone through. But I do think that the mostly free trade between our nations will persist, and hopefully him and Carney will unveil some deals soon. But we just wanted to give a quick market recap, which hopefully that was helpful for people before we turn it over and to our guest of honor now, Lyle Perry. So Lyle, will turn it over to you and start asking you some questions. And again, just for everyone else in the audience, there is a chat function there that you guys can add your questions to. And we'll try, if we don't get to that or cover that topic in our Q&A with Lyle, we'll try and set aside some time at the end to ask a few questions that may not have been addressed. So Harry, why don't you go ahead and ask our first question of Lyle?
Thanks, David. I thought I'd ask just the real basic one to start us off, Lyle, is should everybody have a will?
Thanks, Harry, and thanks again to all of the folk here at Perla Financial for having me on. This is a really good topic. I think knowledge is key in this area, right? If you don't know there's something you need to fix or address, well, you can't address or fix that, right? So knowledge is key, and this is a great topic for this webinar. So thank you guys for putting this on and having me on here. So yeah, should everyone have a will? Definitely yes. And so the reason I'll give the short answer to this one, because I could definitely go on for almost the entirety of this webinar answering this one. But of course, first and foremost, you get to appoint an executor for your estate. So the executor is the person who's authorized to administer your estate once you pass, and you get to appoint who that person is. Secondly, of course, you get to appoint who your beneficiaries are within your will. If you don't have a will, then there's a set defined bunch of laws that decide who gets what of your estate. So obviously within the will, you can choose who your hard-earned estate and money goes to when you pass. Of course, you also within the will, if you have a will, you can specify how the assets should be distributed. So go a little bit beyond just saying it goes to this person. You can get a bit specific on how assets are distributed to certain beneficiaries under the will. And of course, everyone should have a will because you're doing a big gift to your family, right? Without a will, you can firstly increase costs for your family because it does, and we can touch on that maybe a bit later. But there are increased costs because there are forced court applications that you have to go through if you don't have a will. And secondly, of course, it can reduce legal disputes because without a will, you do now bring into play the possibility of other documents being deemed or someone alleging that another document could be viewed as a person's testamentary disposition. Maybe they jotted down some notes about who they want to get something when they die, and now that document could be used in a court application to say this should be viewed as this person's will. And if you don't have a will that formally and legally documents your wishes, you run into those potential issues there. There's a multitude of other reasons, but those are some of the top reasons why you want to have a will.
Thanks, Lyle. You started to touch on what happens if somebody dies without a will. Can you maybe expand a bit more on what would happen in that instance?
Yeah. I think Harry's question is almost better to be answered in the negative. What happens if you don't have a will? So yeah, it's a good follow-up question there. So if you don't have a will, of course, yeah, as I said, you don't have someone who's appointed as the executor. You don't have someone who's authorized to deal with your estate. Now, it's a huge misconception, and I do get a lot of clients coming in to me and say, okay, well, my spouse has died. They didn't have a will, but I'm their spouse, right? I should be entitled to deal with their assets, their bank accounts, the family property that we own. Well, the answer is no to that. You're not. You're not legally authorized. Doesn't matter if you're a spouse, a child of a deceased. If you do not have specific authorization in a will, have not been appointed the executor of that deceased person's estate, you have no authority to deal with any of their assets. And so that's the biggest one. Following from that, because no one is legally authorized to deal with the estate, you then are forced to go through a court application. You have to apply to court to be appointed as what's called the administrator of the estate. So you're the executor of the estate when there is a will, and when there's no will, you get appointed as the administrator of the estate. But now that's a court application, so you have to and you're forced to go through this court application. Of course, the court application means things like delays, so it takes many months to get that done, and of course, costs, right? There's legal costs and court costs that you incur as well going through that. So that's the first one. If you don't have a will, you have to go through those court applications, resulting in delays and costs. And of course, you don't get to choose who your estate goes to. So when you die without a will, it's called dying intestate. If you die with a will, you're considered having died testate. So dying intestate, you don't have a will. There are the laws of intestate succession, the laws that say who gets what, and it's a set formula, right? And so now you're getting your estate divided between in accordance with the set formula and not according to your wishes. So yeah, that's just a few of the downsides of not having a will, and yeah, of course, again, that also furthers the potential for disputes between potential beneficiaries and family members further down the line.
Yeah, perfect. So key takeaway: you should have a will. Can you explain what a power of attorney is, Lyle, and when the right time is to name somebody as your power of attorney?
Mm-hmm. So a power of attorney is a document in which a person appoints an attorney. Now, that's not a lawyer, it's the person they're appointing in that document. You appoint an attorney who's authorized to make legal and financial decisions on your behalf. So essentially, you're authorizing them to deal with your assets. So things like dealing with your bank accounts, dealing with CRA, signing things on your behalf are all authorized and permitted under a power of attorney. Now, when would you normally see a power of attorney used? Typically, it's when someone has lost capacity. So either through age-related illness or Alzheimer's, dementia, or through an accident. But not always, though. Powers of attorney can be used for convenience purposes as well, depending on what you choose within that power of attorney. You know, if someone's out of the country, you could potentially use the power of attorney, and the attorney is authorized then to sign documents on your behalf, deal with banks and those sorts of things while you're away. And also, if someone, let's say in a spousal couple, one spouse is more immobile than the other. Now, if the spouse has been appointed as the attorney, they can now use that power of attorney to attend to, again, the banks or any sort of appointments they need to attend to on behalf of the donor, the person who's granted them the authority as the attorney. So, yeah, those are some of the benefits and when you might use a power of attorney. When's a good time to appoint it, you ask? Well, you can have a power of attorney done at any time, provided you have capacity, right? So unfortunately, this is one of the worst parts of my job where I have the duty to, where I have a client bring in their elderly parents and they say, well, my mom or dad wants to make me the attorney under a power of attorney. And of course, I'm legally obligated under Law Society rules to do a bit of an assessment with them. It's not a medical assessment, it's a legal test as to what their capacity is. And I ask them questions, well, what's the value of your home? You know, do you have a mortgage? And they can't answer those questions. And of course, if they've reached that stage of incapacity, they can't do a power of attorney. So for me, I always say get a power of attorney done whenever you can. The earlier the better, right? Because unless there's some significant law change, which there hasn't been in a very long time, we don't really need to change that power of attorney. So get it done. It's an invaluable document. It's one of those documents I say, I hope you never need to use it, but if you do need to use it, you will be exceedingly happy that you have that document because it's going to save you a whole bunch of trouble down the line. Because the alternative is if someone loses capacity, you then have to apply to court for what's called a committeeship application. So that's an application where the court then says, yes, this person is incompetent. The court's essentially stripping them of their personhood, that they can't make decisions on themselves, and giving it to someone else. Now, that application takes months to go through. It's costly, of course, thousands of dollars. And also, it's a very high bar because the courts, as I said, they're taking away this person, essentially their personhood. And so the courts don't likely grant that sort of committeeship application. So it's a high bar. You got to get two medical professionals to give opinions. So it's a huge hurdle to get over for there. And the power of attorney, which is going to cost you maybe a couple $100 to do, will be well worth its money and weight in gold if you actually need that document down the line.
Perfect. Lyle, this is a question that we get an awful lot. Would you advise elderly parents to add their adult children on as joint owners of their house for estate planning purposes?
Yeah, so that's a good question. And so it's a yes and no answer, as unfortunately a lot of the questions in law are. So yes, I do recommend it. It is a fantastic estate planning tool. No, I don't recommend you go and just slap your children on title to your property and say, great, I've done it. I've done some fabulous estate planning. Now, unfortunately, it's going to be a bit of a detailed answer, so feel free to cut in if you have any questions while I'm talking here, because we need to go back to understand why this would be beneficial. And so the idea is of adding children on title to your property is you add them on title as joint tenants with you on title to your family home, your principal residence. Joint tenancy means when one joint tenant dies, the surviving joint tenant gets the deceased joint tenant share. So let's use an example of two parents with one child, right? So you add your child on title with you to your property as joint tenants. Assuming you as the parents pass first, your interest will automatically pass to your child as the surviving joint tenant, and that interest passes outside of their estate directly to the surviving joint tenant. So the benefit is it passes outside of your estate. So that's key. Now, why would that be beneficial to you? Well, we got to take the step back to understand the benefits for that. When someone dies, you often have to go through this process called probate. Now, you may have heard that term before, but I'm going to explain it as if you haven't. So probate is an application to court that is required sometimes when someone dies. Not always, certain circumstances. What it is, the court is firstly verifying that the will is indeed the last will of the deceased. And secondly, they're officially appointing the executor under there. That's essentially what they're doing in that probate process. So the courts issue this thing called a grant of probate. That's what you're applying for from them. Now, it's two situations that can trigger probate. One, which we're going to deal with here, is if you own property in your sole name when you die. That will trigger the requirement to go through probate. That's because the land titles office that transfers property in and out of someone's name, they won't transfer it out of a deceased person's sole name without a grant of probate from court. And so when the death of a joint tenant occurs, that doesn't trigger probate, right? As long as there's some other surviving joint tenant, it doesn't trigger probate. So in that scenario that I had, the two parents plus the child as a joint tenant, first parent dies, their interest passes to the other parent plus the child. And then assuming the other parent passes before the child, their interest passes to the child outside of their estate, and they become the sole legal and beneficial owner of that property at the end of the day. So the benefit of that is we avoid having to either go through probate altogether, or secondly, at the worst case scenario, avoiding probate fees. So when you have to go through probate, when you die, you have to pay probate fees. So it's essentially a death tax to the government. You have to pay them 1.4% probate fees on all the assets that form a part of your estate. Okay, anything that passes outside of your estate, you don't pay 1.4% on. But if you don't have to go through probate, you don't have to pay this 1.4%. So the idea behind adding your children on title is you add your child on title, your interest in your principal residence passes outside of your estate directly to them as the surviving joint tenant, thereby either avoiding probate altogether, that's if you don't have probate triggered for some other reason like your bank accounts, or worst case, as I say, you're not paying that 1.4% probate fee. Now, with the real estate house prices these days, it's 1.4%, on $1 million home, which is fairly commonplace around here these days. I mean, that's $14,000. Then if you have to go through probate, you're paying a horrible lawyer like me about $4 or $5 grand to go to court. So you're already up at about $20,000 cost to you by having to go through this probate just on your real estate prices and on today's prices. So by adding your child on, you can avoid this. But now that you know all the benefits, you can't just add them on title because that's going to create more problems than you're actually solving here. So when we add the child on title, what we have to do is we have to do a trust agreement with that. So what we call it's called a deed of gift and trust. So it sounds very scary, but it's really not. Let me explain what's in that agreement. So that deed of gift and trust in there, your child would be stating that they are holding their interest in your property in trust for you for your benefit while you are alive. Meaning that while you are alive, and I'm saying you meaning the parents, while the parents are alive, the children or the child has no interest or beneficial interest in this property. It's not theirs. They can't mortgage it. They can't sell it. They can't do anything with it. It's the parents' property while the parents are alive. So in law and in accounting, we distinguish between these two terms, legal ownership and beneficial ownership, right? Legal ownership is whose name is legally on title, right, in the land titles office. And so that would be all of you, you and your child or children. And the beneficial ownership is who's really entitled to that property. Who's really is it? Who's beneficially owns that property? And that can be different from the legal ownership. And so in that trust agreement, in that deed of gift and trust, we say the children say they have no beneficial interest in the property while the parents are alive. But then the parents also clarify in that trust agreement that upon the last of the parents to die, they intend to gift the beneficial interest in that property to the child, right? That's why it's called a deed of gift and trust, because it's a deed of trust because the children are holding it in trust for the parents during their lifetime. And it's also a deed of gift because you, as the parents, are gifting the interest in the property, the beneficial interest in the property to the child upon the last of you to pass. And so that trust agreement is of is imperative to do for a number of reasons. Firstly, it protects the parents from the children, right? Because if you don't do this and you add your children on title, if the children get into some financial troubles, let's say they have some creditors coming after them, well, now the creditor is going to go, excellent, this child's got a 1/3 interest in a $2 million property. We're going to go and attach that property to satisfy the creditor's claim against the child. Without that trust agreement, you have no defense to that. The trust agreement, you can say, no, 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 the child has no beneficial interest in this property during our lifetime. Sorry, creditor, you don't have a right to claim against this property. It also protects you from your children's spousal claims. So same thing, if the child got separated or divorced from a partner, that also the trust agreement defeats against claims from a spouse. It also protects the children from capital gains tax liability. Because as you may know, if you own real estate that is not your principal residence, so you don't live in that home as your home, live in that home as your principal residence as your home, then you start accruing capital gains tax liability on the increase in the property. And so with that trust agreement, without the trust agreement, the children go on title, property rises in value, it eventually gets sold one day. The CRA is going to come knocking on your child's door saying, hey, you owned a property that you didn't live in, and now you owe us capital gains tax. But with the trust agreement, again, they have a defense saying, no, no, I had no beneficial interest in this property. I don't owe any capital gains tax on this property. So that trust agreement is vitally important. We don't do estate planning like this without doing the trust agreement for all of those reasons. It's just so fundamentally important for all parties, protecting not only your children, but you guys as well. So that's the very long story on adding children on title. And you need to know all of those intricacies to understand why it could be beneficial and how it may apply in your situation.
That's great, Lyle. I think now is a great time. We've got a couple of questions coming in through the Q&A portion there. Maybe we'll answer the second one first because it's more directly related to that recent comment. So can you put another relative on title other than a child in that, what you were just explaining, the deed of gift and trust on your principal residence?
Yeah, so that's a fabulous question. Again, yes and no is the answer. Yes, you can put them on title. Yep, you can do another relative. But the downside is, and what this normally negates the benefit of doing this, is that you're probably going to pay, well, you will pay property transfer tax. So the reason why this estate planning works is because we can add children on title to a person's principal residence without having to pay property transfer tax. So that's the money, the tax that you pay when you buy property, right? The government doesn't care that you're giving this interest to your child for $0. It's always deemed to occur at fair market value. So if your home's worth $1 million, you pay the property transfer tax on, let's say you were adding your child in that hypothetical scenario, I had 2 parents, 1 child, your child's effectively taking a 1/3 interest in that property. You're going to pay property transfer tax on 1/3 of that property being transferred into your child's name. But with children, so what they term related individuals, we can claim an exemption for the property transfer tax. So you don't pay property transfer tax if it is a related individual that you're transferring it to, and it is your principal residence. If it's not a related individual, like another relative, like a niece or cousin or something like that, that doesn't qualify. Even brothers and sisters doesn't qualify as a related individual. And so, yes, we could do it, but we would have to do a little calculation there because you're going to pay the property transfer tax. And so maybe that would be, a few $1,000s. It depends obviously on the value of your property and how much interest they're essentially taking, and then work out how much are you going to save in probate fees at the end of the day and say, is this proposition going to work? Is this a good value proposition for you, right? If I'm saving 30,000 on probate fees and it's going to cost me $5,000 to do it or $6,000 to do it, well, yeah, that makes sense, right? But if we're at 10 and 10, well, maybe that doesn't make sense. Or maybe it does, because again, property value is going to increase, and as property values increase, probate fee value is going to increase. So maybe it does. But again, that's just a case-by-case situation. We'd have to decide if that makes sense. So yes, you can do it, but it costs more, which can negate its benefit.
Perfect. And then the other question I think we can answer right now too is, do bank accounts assigned to a beneficiary allow funds to be transferred outside of probate and outside of the will? And I think I can help to answer this question initially. So most bank accounts do not allow, well, no bank account that I'm aware of allow you to name a beneficiary per se. So beneficiaries can only be named on registered accounts. So things, and life insurance. So things like a registered account is like an RRSP or a tax-free savings account, a pension fund. You can name beneficiaries on that. And when someone dies, the holder of the account has named their 2 children as beneficiaries. The money goes directly to those beneficiaries outside of the will with a death certificate. It can be settled very quickly. But bank accounts do not allow you to name a beneficiary. You may be referring to perhaps like a joint account holder. I think is probably what they're talking about, Lyle. I don't know of any joint beneficiary for bank accounts.
Yeah, David, the other thing they may be asking is, can they also be put in this deed and gift of trust? Okay. That might, I'm just assuming, I didn't see the question, so that might be something that Lyle can answer. I already know the answer, but.
Mm-hmm.
Yeah, so and I think David can probably add on to this as well. Yes, and that would be a good question if that's what the participant was asking there. We can incorporate other assets other than real estate and bank accounts into that deed of gift and trust. It's quite easy to do that. It just becomes a little bit complicated with the bank themselves doing this. So you can do this if you add your child, in this case, as a joint owner of this bank account, right? Typically, when joint owners of a bank account, one joint owner dies, the surviving joint owners continue with that bank account. And I say typically because not all banks do that, and they can create some issues. And rightly so. I'm probably going to give you a bit more information than you need here, but in law, there's a presumption. If you own property jointly with a child, so if a parent owns any asset jointly with a child, the presumption in law is that the child is holding it in trust for the benefit of, is holding it in trust for the benefit of the estate of the parent, meaning that the presumption means where you start. It's the position where you start. So it is presumed that the child is holding it for the parent's estate, meaning that if you don't have a document to the contrary, then that's what the courts will say. Yes, that's the position. The child was holding it for the deceased estate. And that then ruins all your estate planning, because now you're holding it for the estate. So it's considered an estate asset. So you pay probate fees on it, and it can trigger probate. But a presumption is all that. It's just a place to start. And to rebut a presumption, you have to have evidence to the contrary, which is why this trust agreement works, because the trust agreement is your documented intentions of what you want to do with these assets, which can include the bank accounts. So you can add your children on as joint owners to these bank accounts. We include that in the trust agreement. And then we hope then when you die, then those bank accounts, the bank continues with your child as the owner of that bank account once you die. My advice to clients when doing that is you have to be very clear with the bank and saying to the bank, hey, I am giving this account to my child, and it is to be theirs. I tell clients, use these words. I want the right of survivorship to apply to this bank account. You need to be very forceful with the banks when talking to them, because you don't want the messages to be crossed here. You say, well, how are you documenting that on your system that you want this right of survivorship to apply to this bank account? Because again, you can get into some bad situations where you add them on, you think you've done the right thing, and all they're being added on is as an authorized signatory. And that's not doing anything for your estate planning, because then when you die, the bank says, no, that's still the parent's account. It's held for their estate. Too bad. We still require probate in this case, or it forms a part of the estate.
Okay.
Yeah. And anything you want to add to that, David?
Nope, I think that's great. I think it's just clearly documenting that intention is critical with non-registered accounts, whether it be a bank account or an investment account. Like WorldSource has said that we can do this. Their position that you can do this, but You have to be very clear with what account number you're referencing, and you have to have that deed of gift and trust done by a lawyer like Lyle to allow for that to happen.
Yeah, and so that's very new. What World Source is doing, that's very new. That, and I think one other institution I've heard about them allowing this sort of arrangement and formally allowing it. You know, what we've been doing in the past is I wouldn't say we're we're working the system really, because that's not what the intention was for putting children on your bank accounts. That's not what the banks. You really shouldn't be going to the bank saying, "I'm adding my child on for estate planning purposes." They don't want you to do that. But
No.
WorldSource is doing this now and recognizing that people are doing this and actually allowing us to do this appropriately. And they've said, "Oh yeah, we'll honor this provided it's documented properly," which is honestly quite fundamental and phenomenal for estate planning, that we actually have someone who honors this and understands this is what people are doing. This is legitimate estate planning strategies here. And so yeah, that's really great that World Source is able to do that. Yeah.
Perfect. Lyle, you just went through an example of using a trust as part of the estate planning. Are there other instances where someone should consider incorporating trusts into this part?
Yeah. So yeah, exactly. What we were talking about there, that's exactly it. That is a trust, right? We're using trust, but that's not a trust that we're doing within the will, right? This is a separate, what we call an inter vivos trust, right? We're setting it up during your lifetime. The trusts that we typically see in estate planning are the testamentary trusts, which are the trusts that are done in your will, right? Pursuant to your will. And yeah, we can use trust for for a lot of good benefits in your will. Of course, the first one that comes to mind is for minors. So under law, a minor in BC, that's anyone under 19, is not entitled to inherit in a will, right? They can't get their money. So if you've got a 10-year-old beneficiary, of course, they don't just get their $1 million or whatever they're getting as a beneficiary. It it gets held in trust for them until they turn 19. And when they turn 19, they get whatever's left of their share for their own use to use. Now, you have to put in those trust terms within the will. And that's another reason why you should have a will, because if you die without a will and you have a minor beneficiary, well, now you haven't appointed someone to be the trustee of those minors' share in your will. And so now you got to get the public guardian and trustee involved. And that's essentially a government entity that now steps in when there are minors who don't have a trustee appointed for their funds. And so within your will, you can appoint have these trust terms for minors. Firstly, at the very basic, just appointing someone to deal with their assets until those minors' assets for them until they turn 19. But what we commonly see is using the trust to deal with assets for minors past 19. So you have the option in a will to say, no, you know what, I probably don't want my 19-year-old getting a bunch of money and having it for their own use and for them to decide what they do with it. They probably wouldn't make a great decision with that money. So I'm going to put it in trust for them until they turn 25 or 27 or whatever that age may be. You get to decide that. Now, it doesn't mean they don't get access to it until that age. Let's use 25 as an example. It doesn't mean they don't get access to it until they turn 25. It just means that their access to it is subject to the executor's discretion. So or the trustee's discretion. That trustee is often the executor. You use your executor, who will be the trustee for the children's funds. But that trustee decides when they get access to their funds and for what purposes. And so, as another example, if your trustee says, oh, this minor or this 20-year-old beneficiary whose funds are being held in trust until they turn 25 wants to buy property and they need to use all of their funds, your trustee can say, yeah, that's a perfectly good use of your share of the estate. Here we go. We'll give you all the funds to purchase that property. But it just gives someone else who's more responsible than your 19-year-old child making decisions about their funds. So that's one of the common areas we see trust being used for in wills. You can also use it for beneficiaries where you have some issues and you don't want them getting the funds for their own use. So, if you have some questions around their money management skills, you can put it in trust for them until whatever age you want, or even indefinitely. And it just gets held by the trustee that you appoint in your will to deal with their funds. It also can protect the beneficiary's inheritance from creditors, from spousal claims as well. because when things are put in a trust, they are not held by the beneficiary. It's held in the trust, and it's not deemed as an asset in the beneficiary's hands. And so that is another benefit and options that we use trust for in a will. We also can use trust for in families where you want to preserve the capital of assets. So let's talk about money. If you've got a bunch of money and you want to preserve that capital in the money, you can put that money in trust and allow the interest to be spent or given to beneficiaries, but that capital then gets preserved, and then again you can choose what happens with that capital at some time in the future, right? So you get that flexibility. Because remember, in a will, I often get clients coming to me saying, I want to gift this amount or this item to someone, but I want strings attached. I want X, Y, Z to this. I say, you can't do that. A gift is a gift. Once it's being gifted to someone, it's theirs. They get to use it. So you can't put those strings attached if you're gifting items. You can put strings attached if you do it within a trust. And so we can do all of those sorts of things within a will. And again, it just gives you flexibility and options that you have, because everyone's family is unique. And that's part of what we do when we meet with someone. We get to know them and their family. And if they've got some beneficiaries that they need to impose these trusts with, then we can definitely come up with solutions that work for them.
Perfect. Can you maybe comment or give some advice on best practices for who someone should choose to act as their executor?
Yeah, that's it. One other thought on the trust there. One other thing we've used trust for, and this is really important, we have to bring this up, is for beneficiaries who are receiving disability benefits. I've seen people bring in wills and they have beneficiaries are receiving disability benefits and they're being gifted outright assets in the will. Now, the problem with that is if a person who's receiving disability income assistance, they can, by being given a gift in a will, be disentitled to their disability benefits. That's because oftentimes those disability benefits have some limitations on the assets that disabled person, the PWD, the person with disability, can hold. So total amount of assets that they can hold and total amount of income that they can earn. And if they exceed those thresholds, then they get cut off from their disability benefits. And by doing an outright gift to them, you would potentially disentitle them from receiving those benefits. And so by using trusts, we can put it in we call it a fully discretionary trust, or what's also called a Henson trust. And so that just means that the trustee of that trust is the person who makes all the decisions as to when that money comes out. So the beneficiary has no say when money comes out there. So it's at the full discretion of the trustee who decides when they get that. And if we use that trust, then the funds sitting in that disabled beneficiary's trust fund is not considered an asset in their hands and therefore won't disqualify them from the benefits. So if you have anyone receiving disability benefits or may potentially receive in the future, you have to get a will with a trust term involved in there.
Yeah,
David, jumping back to your question there,
great point.
who we should point to act as your executor. Well, it's really up to you. What we commonly see is spouse. If you're in if you have a spouse, you say, I appoint my spouse first to be the executor. And then you appoint an alternate, right? Because of course you want an alternate in the event that you die, if you're the last of the spousal couple to die, or of course if you die at the same time as your spouse, then you need an alternate. Again, what we often see, it's not correct, but it's just what we often see, is the alternate would be an adult child there. So we have spouse and adult child. Of course, not every situation works where you can do spouse and child. And in that case, we try and come up with some solutions of someone else who's responsible. Remember, the executor is also not just given free reign. They don't get to just do whatever they want. They have to act in accordance with the will, and they're bound by laws in accordance with WESA, the Wills, Estates, and Succession Act. And executors are accountable to beneficiaries. So if you are a beneficiary and you think the executor is not doing a good job, or you think they're doing something fishy, they can be held accountable in court. And so, it's not a free reign on an executor on what they can do. But if you're in a tricky situation, which happens at times where you don't have someone you can appoint, there are trust companies. So companies that do professional, who will be an executor for you. So a lot of the banks have these sorts of departments where they're trust departments where they'll have someone who can be your corporate executor. So you appoint a bank, and then they will do that for you. The downside to that is they charge money for it, and usually handsomely for that. And especially if you've got a big estate, they usually base it on percentages with a minimum fee they'll charge. And if you've got a large estate, that number can be really high, so it can be quite expensive. And then also just makes the estate planning process a little bit more complicated because you do have to send the will to that company. They request some clauses to be put in there. Nothing substantive. They don't change who gets your assets, but the clauses relating to what they can do as an executor of your estate. But yeah, the executor really is up to you who you want to be the executor. But remember what I said earlier, the executor is the person who's authorized to deal with your estate. And if you don't have someone appointed, no one is authorized to deal with your estate, and you have to go to court to appoint someone who is authorized to deal with your estate.
Thanks, Lyle. Lyle, if I was named an executor, and let's say it's well down the road, and I just don't feel like being the executor of that will, and am I able to sort of go to you or hire a lawyer to help me or take over that responsibility if I just don't want to be the executor of a will?
Yeah, so if that was a situation, excuse me, and of course, you can't be forced to be an executive. So one of my again advice to clients is if you're appointing someone as your executor, probably should chat with them and make sure they're okay to do it, because they can just, one of the options, Harry, in that situation is you could just renounce as an executor and say, hey, I don't want to do this. And it's quite simple. You just sign a renunciation certificate saying, no, I don't want to be an executor. I haven't intermeddled with the estate. I haven't done anything in the estate yet, and I'm out. But if you want to continue to be the executor, and even if you're reluctant, you definitely can get assistance from lawyers, accountants, or any other professional that you deem appropriate in that circumstance. So those things are not only accepted, but they're defined as estate expenses for the estate. So you as the executor, you should never be out of pocket for anything you do as an executor of an estate. So every expense you pay, you get reimbursed as an executor, and you're well within your rights and entitled to hire lawyers to assist you or accountants to assist you. And I'd recommend both in a lot of situations, especially if you have to go through probate, like we chatted about earlier. You definitely should be doing that through a lawyer. I've got a lot of very comical stories of people trying to do it themselves and making an absolute mess and costing themselves double of what they would have cost in the first place. But yeah, you absolutely can use lawyers to assist you with those sorts of things. And accounting advice is also vitally important in dealing with an estate, because as an executor, you have to deal with the deceased taxes, right? You have to file their terminal tax return as well. And so you should be doing that with an accountant's advice. And that advice is important because you as an executor can be held liable, right? You can attract personal liability for what you've done in the estate, and you have to adhere to a certain standard of being an executor for that estate. And so using the professional advice and assistance not only helps you out, gives you some guidance on what you're doing, but it's going to lower any sort of risk or possibility of you getting into trouble, because remember, executors are accountable to beneficiaries.
Um, are there any useful estate planning considerations for blended families that are different from standard?
Yeah, so blended families are very unique situations that need a lot of attention with estate planning. So just for everyone listening here, blended families are where you have, let's say, a spousal couple, and the one has children from a prior marriage and the other has children from their prior marriage, right? And now they're married together. The risk in those situations there, Kevin, would be that, let's say we got this couple here who've got children from prior marriages or prior relationships. Spouse one dies, and in their will they've said everything goes to my spouse, which is common in a spousal situation. So then the spouse gets everything, and then this spouse changes their mind later down the line and says, hey, you know what, I don't want to give anything to my now deceased spouse's children from a prior marriage. I never really liked them anyway, and so I'm going to change my will and I'm going to give it to just my children alone. Now this person who's the deceased, their children get nothing. They get no benefit from their parents' estate. And so those are risks. One of the more common situation would be this person passes, everything goes to the spouse. This spouse then gets remarried, right? So less sinister than my first example, gets remarried. They then change their will and say, well, I'm going to give everything to my new spouse, right? Which is common again. Everything goes to new spouse. This one dies. Well, this new spouse is not giving anything to that first spouse's children? Of course not. He or she's got no relation to that. And now again, those child or children have been cut out completely. So with these blended families, we've got really two options we can do. One, we can deal with mutual wills. Now, I'll preface this by saying I don't use mutual wills a lot because they do have a couple issues. I'll tell you about them in a second. So what mutual wills are, where you still each do a will, but what you agree to is you agree that you will not change your will. So meaning that one spouse dies, the spouse now can't subsequently, after the death of the spouse, go and change their will. And so, of course, you come up to an agreement saying, oh, yes, if I die, when the last of us dies, we'll divide it equally between our respective children. So that those two children from the first marriage and this person's children from the prior marriage as well. And so, that works, and it definitely can serve a purpose and works in certain situations there. And the issue comes in where the law is a little bit gray on whether this spouse can how far they can go in terms of encroaching on those assets, right? So yes, they've got these mutual wills saying when the last of us dies, it gets divided between all of our children. But what if this spouse goes rogue and just spends all the money or gives away all the assets during their lifetime? Are they allowed to do that? Well, the law is not clear about on that, and so there's no legislation that deals with that sort of scenario. So in my mind, that raises a risk for some legal claims later down the line, both from children of both sides of the deceased spouses. And so that is one option, though, and I definitely don't take it off the table, but I don't use it very often. The other way we can deal with this is, again, trusts, right? So trusts within a will, we can deal with this. There's two sorts of trusts we can use in these situations. The one is what we would call a life estate, or a life interest. So what that is that the spouses give the other spouse, the surviving spouse, a life interest, the right to live in the family home, because that's obviously the biggest one that comes up. Because again, I'm using my two examples here. These two married couples, they've got children from prior marriages. This spouse dies first. Of course, this spouse doesn't want to leave the surviving spouse without a home, right? We don't want to say, hey, my 50% of the home must go to my children. Well, what does this surviving spouse do now? They only own 50% of the home. So that can obviously be a huge hardship for this surviving spouse. So in the will, you can say, I'm going to give my spouse the right to use the matrimonial home, our principal residence, for as long as they need. Right. And so that allows this spouse to live in there and do what they want with it. But as soon as this spouse either doesn't need that property anymore or dies, of course, then that property forms back a part of the respective parties' estates, and 50% can go to this person's prior children from a prior marriage, and the 50% can go to the other spouse's prior marriage. And so that life estate, again, you can also put some specifics on how that life estate works, who's paying for, if there's a mortgage, who's paying for the mortgage, who's paying property taxes and those sorts of things. And you can address that all within the trust terms within the will. But that's a very common one to see as well. And that deals with the real estate, of course. We can also do spousal trusts to deal with property. Like I briefly touched on earlier, you can do where you say, when you want to preserve the capital of an asset, you say, well, here's the capital. I'll let all the income earned from this capital, let the surviving spouse use it because they need to live and they need money to survive on. But then when the spouse dies, then again, that capital forms back a part of the first deceased spouse's estate and goes to their children, so their children don't get excluded. So yeah, there's options to deal with it, but you have to we have to address this and apply our minds and look at the intricacies of that situation and come up with something that works within your will to ensure that your children or your beneficiaries don't get cut out down the line.
Just a follow-up question on your mutual will example. What happens in that scenario if one spouse passes away and the surviving spouse then remarries? Is there at any point that they are allowed to adjust that will?
No, and so again, that's another one of the huge downsides to that. It's a great question, Kevin. So the mutual wills, it just doesn't account for future situations, even if it's not sinister situations. That spouse is now legally bound. They are not allowed to change their will, and if they do, it gets deemed null and void in court, and the court will say, no, you had mutual wills, you agreed you wouldn't change your will, you have to comply with the original mutual will that you did with your former spouse. And so yeah, that's again another one of my downsides. It just doesn't work. It locks you in, and it might work in some situations, but in other situations, it's going to potentially produce a wholly unjust situation that you don't really want or intend, and you're bound by that.
Thanks.
The blended family questions are so nuanced, and I find that I have all these like, well, what if this, what if that, and I don't know if anyone in the audience is of this situation, but my concern would be like if if it was me or a family member or client, my worry would be, okay, I have blended families, and one spouse passes away, who maybe it was their matrimonial home, from their previous marriage, and maybe their first spouse passed or whatever, and then the new spouse comes in and lives in that home, and then the will gets updated, and that new spouse is going to be the beneficiary, with the understanding that the kids from the original marriage or whatever would eventually inherit that property. But what happens if the surviving spouse from the first marriage then passes before the new spouse? Then that new spouse, like what should the beneficiaries of that first parent do at that point in time? Should they start to make a claim right away on that asset, or how do people protect against that situation, Lyle, from going too far?
Yeah. So it can get very complicated for sure. Yeah. So I think the responsibility should be on the parent in this case. So the way you can try and prevent that is by not having the property. So one of the downsides with the blended families is that you lose a bit of tax efficiency, right? You start now of not being able to avoid probate in these situations. And the reason for that is because when you're trying to, as you say, let's say one, and it very often happens that one spouse coming into the second marriage, brings in 80% of the value of this home, or whatever the case may be, or it's 100% their home, you know, and then they live in this, and then let's say they sell this home that this one owned, and they buy a new home. Well, what you have to do is you can't own the property as joint tenants, because remember, as we discussed earlier, when one joint tenant dies, the surviving joint tenant gets the deceased joint tenant share automatically. It passes outside of their estate, and it doesn't matter what their will says, or if you've got trust in your will, it passes outside the estate to the surviving joint tenant. So you can say what you want to be scream blue in the face in your will about trust, that doesn't apply to the home. So the responsibility should be for the parent, and have the foresight to this, is that when registering the property, and again, your lawyer should be discussing this with you in a blended family when doing a real estate transaction, you should own the property as tenants in common. So that's the other way you can own property with multiple people, is a tenant in common, and you can own a percentage. It doesn't have to be 50-50. You can own 80-20 or whatever the case may be. And then when a tenant in common dies, their percentage interest forms a part of the estate. And then, of course, if you have trust terms in your will, like a life estate and those sorts of things, well, then that 80% is subject to the trust term in the will. And so, yeah, again, another important part when purchasing property with blended families, you should probably contact your lawyer ahead of time just to discuss how things should go on title. And because, yeah, it's of fundamental importance. You don't want to say ruin it, but you could essentially defeat planning. But don't worry, again, if anyone's listening and you do have property owners joint tenants, you're like, oh no, what have I done now? You can change that, and that's okay. But it's just, again, another thing to keep in mind. As I said earlier, knowledge is power. If you don't know these things, well, how do you know to fix them? So yeah, you can address them and put in some safeguards there at that time. To directly answer your question, yeah, at the time of someone dying is the time you need to bring a claim. Yeah, a child could bring a claim even on the death of the first parent. So again, in my hypothetical scenario, spouses here who got children from prior marriages. If this spouse dies and everything goes to this spouse, and these children are like, oh, hang on, I might get cut out of the surviving spouse's will and estate. Well, yeah, they need to bring a claim at the time of their parent's death. That's the time to bring a claim. Yeah.
Okay. Well, we're right up against 7 o'clock. We've got one more question that I think you can probably answer fairly quickly. We've talked a lot about trust, and I have a feeling this might be the answer here. But if somebody has one child that they know is very financially capable, they have no issues with them receiving an inheritance outright, but they have another child or children who may have like a dependency issues or other challenges, or just isn't fiscally responsible, has a history of making really poor decisions when they've had money. How can they protect the financially irresponsible child from maybe squandering their inheritance?
Yeah, well, we have talked a lot about trust, and trust is the answer in this case here. So yeah, just like you can do it for children, minor children, and hold their interest and trust up to a certain age. Well, yeah, you can put someone who is has some dependency issues, and we get that a lot. You have a client comes and say, hey, my son is an addict, and they know that any money that they get gifted under their estate is going to go to fueling that addiction, right? And they don't want that, and they want their money to be spent wisely on their child. Yeah, we put it in trust for them, and again, you can put it in trust for them indefinitely. You don't have to say at age 30 they get what's left of their share. You can say it's held in trust indefinitely until they die, essentially, and you'll plan what happens if they die and there's still money left in their fund. But it gets held in trust for them, and then someone, the trustee, the person who deals with the funds for that beneficiary, decides when they get it, and oftentimes it's then used where they give them a little bit of money each month, right? Or they buy certain other assets for them that are more beneficial for them than rather than that beneficiary just getting a lump sum of cash when the testator dies, because they know that's just going to be squandered. So yeah, we definitely do that in those sorts of situations.
Perfect. Well, I
And
don't
just
see.
one other
Oh,
thing, David. Sorry,
yeah.
I know we've talked a lot about trust. One thing to note, though, trust can only be done by lawyers. So you can't. Notaries can do wills, but they're not permitted to do trusts within a will. Right, so they can't do minor trusts past 19. They can't do spousal trusts. They can't do life interests. They can't do trusts for beneficiaries who have financial issues or dependency issues. They aren't permitted to do that. Only lawyers are permitted to do that. So lawyers are notaries by profession, but notaries are not lawyers. So just a heads up, sometimes a notary can work for a will where your will is simple, but I can tell you, everyone comes into my office and says, Lyle, it's a simple will, I promise. We dig down, I get to know them and their estate, and it's not simple, and we need to put in these trust terms. And so, yeah, you do need trust terms sometimes. Sometimes you don't. But just know that only lawyers can draft those trust terms in a will.
That's great. I didn't know that, so I learned something new today. So I don't see any other questions in the Q&A, but if anyone has them, maybe quickly fire them in there. And if we don't have time quickly here to answer anything else, we'll be sure to send you a direct reply with an answer. But really appreciate your time and generosity here tonight, Lyle, to sit with us and answer all these questions. And if clients do want to, or anyone who's attending this wants to speak with Lyle, please do reach out to us, and we would be happy to pass along his contact information to you. But again, it's Lyle Perry. He's with MHWP Law in Maple Ridge, so you can Google him too, and I'm sure contact him that way. But yeah, really appreciate it, Lyle. Thanks so much for your time tonight.
Yeah, you're welcome.
Thanks,
Thank you,
Lyle.
guys. Yeah, thank you very much. Yeah, I'm passionate about this topic, so I love chatting about it. So thank you for having me on.
We really
As are
appreciate it.
we. Yeah, thanks. And thanks everyone for who chose to attend tonight. We really appreciate it and hope you found it valuable. And like we said before, if you guys do have any outstanding questions, we're here to try our best to answer them. And of course, if we're not in a position or we feel that you should speak with a lawyer, somebody like Lyle, of course, we can put you in touch with him.